for delivery of judgment WPC 5012/2023 Masuda Begum versus the Union of India.
This writ petition is dismissed.
Division bench item 1.
Item number 3, advance adjournment is being circulated, and here this second API is student is attending the hearing in your.
But it's very difficult to make.
My lord, only one day because this has come suddenly that particular date. So you are not anticipating that particular date.
Because this is not only
2 days, 2, 3 days
one
explanation.
time, but we are proposing that if we will hear the petitioners, and then a short date will give after 1 or 2 days or next week, we'll fix it for hearing the email. Otherwise, constitute a bench is becoming very difficult.
When my lord, let it be on 19th.
We'll hear the petitioners today. After that, we'll fix it.
My lord, so my learned friend has given the sleep yesterday, that's what. I
I
have not.
understand, but to constitute.
I understand,
It's a kind of matter and we
Your lordship.
can't help it.
Can it be then in the next week, but
Except we will have to leave it to the registry. Okay. Because my brother also has difficult bench. Okay. Item 3. Which is represented on the prayer made by Judge Boran and standing us for GMP. Today. Next, this being all pending matter. So it is made clear that on the next date of listing, no prayer for adjournment shall be considered from either side. List. List after a week on a date to be fixed by the registry.
Daily list item 1 for orders.
Wait, my lord. This review petition file and my lord, there is a condonation of delay, my lord, for 370 days, my lord.
your explanation would be still from, 15/5/19, 15/5/19, then this is, this application was filed
Yes, my lord.
on 7/1/2022. The order under challenge is 16/5/19, and the application was filed on 7/1/22.
2022.
So this will be about 2.5 years.
Yes, my
And you
lord.
are seeking condonation of only 370 days.
But my lord, during COVID period, my lord, that was my lord excluded, my lord.
What will be the explanation, but come to
Para 5, my lord, my petition, my lord.
see this, days cannot be washed away. COVID will be an explanation to condone a particular number of days. But you can't exclude from calculation.
That is not there, my lord.
Period of exclusion means what? If supposing you want to file a what you call the appeal, and this is Saturday, Sunday, what do you do? Saturday, Sunday, you take it out, no? You make a calculation and then say that Saturday, Sunday, so 2 days may be given a grace. What will you say? 20, proceeding from 20 to 21. 1 year, 9 months, can't you wish away? Okay. I think that is 7/1/2022. Order is 16/5/2018. You see, this judgment which you have annexed of the Supreme Court,
Yes, my lord. Next.
that we have seen, the exclusion would be only if you file on the reopening day. If you have not filed,
Yes, my
your delay comes to 3 years, 1 month, 16 days. And therefore, the only way is that you can, it's your choice, you can bring an affidavit to explain that delay. Otherwise, we will have to dismiss it.
I will file an affidavit.
Because the exclusion will come only when you file it in the reopening day.
Yes, my lord. Extended till 15/3/2021.
But that doesn't say that even after a year, if you file, you will still get the extension of time. This order of the Supreme Court doesn't say so. You see this order at page 16,
Yes, my lord.
this is which you are relying on. This order is of 23/9/21. The Supreme Court is conscious about the fact, and therefore what they say is the date of order is 23/9/21.
Yes, my lord.
Then it says that till 310 you exclude. It doesn't say that after 310 you will have the exclusion again.
Limitation, yes, my lord.
So what to do?
We file an affidavit, my lord, that
Exactly, President. Mr. J. Hathulia, Learned Counsel for the
M. Kalikanan.
M. Kalika, Learned Counsel for the petitioner. Case for granted a week's time to file an affidavit. Just after a week on a date to be fixed by the registry.
Obliged.
Item 2.
Just a moment. Before that, you see, my court query that from the date of the order under review, the till the date of filing of the review petition, the delay comes to about 3 years, 1 month, 16 days. And not 370 days as projected. Accordingly, you had that. Not 1 month, 3 years, 0 means 5. Okay.
Obliged.
Item 2 for orders.
Yeah, Lordship, my lord. We have filed an IA because there was abnormal delay in filing the review petition. And my lord, there is delay of 2,233 days. The reasons, my lords, I have explained in para 2 of the IA. The order was passed, but it was not informed by my lawyer. That's why, my lord, I could not know. But when I came to know, immediately I went to tribunal, obtained the certified copies, and thereafter collected money, and in that manner, the IA has been filed. So, my lord may be pleased to issue notice
That expenditure is insufficient.
Regard, my lord, I have given citations, but two citations I think your lordship would be satisfied. That is by note 1981, SCC 2788, para 3. If your lordship permits, but then I may read the
1981.
1981 2 SCC 788, para 3.
788.
788, yes.
Second citation.
Second citation, it is 1998 7 SCC 123. Other citations I do have, but these two I think your lordship would be satisfied. What the Honorable Supreme Court said that nowadays, normally the clients depend upon their lawyers. May I read for a while the observation of the Honorable Supreme Court?
The relevant part, not the entire paragraph.
Yes, para 3 I am reading. The disturbing feature of the case is that under our present adversary legal system, where the parties generally appear through their advocates, the obligation of the parties is to select his advocate, brief him, pay the fees demanded by him, and then trust the learned advocate to do the rest of the things. The party be a villager or may belong to a rural area and may have no knowledge of court's procedure. After engaging a lawyer, the party may remain supremely confident that the lawyer will look after his interests. At the time of hearing of the appeal, the personal appearance of the party is not only required but hardly useful. Therefore, the party, having done everything in his power to effectively participate in the proceeding, can rest assured that he has neither to go to the High Court to the inquire as to what is happening in High Court and with regard to his appeal, nor he is to act as a watchdog of the advocate that the latter appears in the matter when it is listed. It is no part of his job, Mr. A.K. So, my lord, this was discussed, and finally, the Honorable Supreme Court passed order. Can you see the last part? Last part below from 4 lines. As we feel that the party is not responsible because he has done whatever was possible and was in his power to do. The cost amounting to rupees 200 should be recovered from the advocate who absented himself. The right to execute the order is reserved with the party represented by Mr. A.K. Singhvi. Similarly, my lord, this 1998 SCC 7123, it is said in para 11, rules of limitations are not meant to destroy the rights of the parties. Paragraph 11. Rules of limitation are not meant to destroy the rights of the parties. They are meant to see that parties do not resort to dilatory tactics but seek their remedy promptly. The object of providing a legal remedy is to repair the damage caused by reason of legal injury. The law of limitation fixes a lifespan for such legal remedy for the redress of the legal injury so suffered. So, Honorable Supreme Court discussed various aspects of the case and finally passed this order, that is para 14. First lordship, para 12, a court knows that the refusal to condone delay would result in foreclosing a suitor from putting forth his case. There is no presumption that delay in approaching the court is always deliberate. The court has held that the word sufficient cause under Section 5 of the Limitation Act should receive a liberal construction as so as to advance substantial justice, vides so and so, so and so, so and so. And finally, court ordered that is 14. In this case, explanation of the delay set up by the appellant was found satisfactory to the trial court in the exercise of discretion of the High Court, went wrong in upsetting the finding, more so when High Court was exercising divisional jurisdiction. Nonetheless, the respondent must be compensated, particularly because the appellant has secured a sum of rupees 50,000 from the delinquent advocate through the Consumer Dispute Redressal Forum. We therefore allow this appeal and set aside the impugned order by restoring the order passed by the trial court. So, my lord, similar orders I have also. My only prayer is this: let the notice go, and or your lordship may also accept, because parties are state parties. And I have a good case on merit, and I think I would be able to satisfy your lordship on those points.
Yes, Mr.
Fact, Madam, the present judgment itself, it is clearly, Madam, I used to read from para 7 onwards, Madam. Para 7, it is said, the learned single judge then observed it when the party is utterly negligent.
Very good, please.
Madam, same judgment which my learned senior friend is making.
Para?
Para 7, Madam. 7 onwards.
Of Rafiq or Balakrishna?
The 1998 7 SCC, Madam.
Oh,
And Balakrishnan.
Balakrishna.
Para 7, my lord, one thing it is there, my lord. Single judge observed it when the party is utterly negligent, he cannot be permitted to blame the council. Learned single judge has further remarked. That part, my lord, what my submission is, my lord, here, what is the vigilance on the part of the petitioner? My lord, he is blaming the advocate. Advocate is appearing in this case. He participated. He argued the case, my lord. And the judgment, the first one, my lord, the 1981 2 SCC relates to, my lord, the dismissal for non-appearance of the, my lord, advocate for the petitioner. In that case, my lord, that is a different case. My lord. If the petition, the advocate did not appear on that day, my lord, and for that reason, definitely, my lord, the order may not, it may prejudice the petition. It's a delay, my lord, it's a negligence on the part of the counsel of the petition. But here, it is not that much. The petitioner appears. What is the vigilance on the part of the petitioner? What is the pleading that sees the petitioner in the pleading in the delay condonation petition? Simple application, simple para 2 of the petition, it is states, my lord. Para 2, what is the explanation, my lord? The applicant begs to state an Honorable High Court pass an order on so-and-so, but after passing the state order, petitioner's lawyer did not inform him about the passing of the impugned order in time. Is it not the duty of the petitioner to take instruction from his counsel whether what is the progress of the case? Moreover, he has suffered from ill health, and due to having no any other senior members in his house, he could not take appropriate legal steps to settle the impugned order in his time. However, so this is the only explanation, man.
Supplementary list, item number 20. This matter already fixed on 2nd June.
No, but the other side also, they call me up, they say. Otherwise, both sides, he also, the other side council also is not possible. Anyway, like, they have related coordinate to solve it. I have seen them, I see them. In fact, Mr. Kadir is, I think he is not part, he's not in council. Anyway, related to follow, I am.
Respondent or assessor? MJ Kadir.
Talukar calls me up. If they leave the hospital, so if someone is must take me as well. Also, when gave me doctor in Madras, in Chennai, he called me from Chennai also. We are for them. Yes, I find you, you're not right. All of them.
Mention of the
Next. Item number 18, Lordship. Okay, customer for 18. I'm for a petition. I think the concept of the search.
May pleasure, Lordship. Lordship, with the consent of the other side, I have to mention item number 4, my lord. My lord, any date may be fixed, my lord.
Okay. Then in item number 14, my lord, we have circulated the adjournment slip, my lord, with the consent of the other side. And for the appellants. Lordship, we have filed the slip yesterday.
I'm on behalf of the respondent lordship. This matter is in the 8th of February, lordship.
April.
May.
May, 28th of May. Thank you. Public.
So with the consent of the other side and table mention item 12, taking consent of the appellate. 12. We have been repeatedly engaged, madam. Just for a week or 10 days. After 10 days. April 28th,
May it please your lordship. Lordship, I beg to mention for listing of an CRPIO.
Lordship, item number 11, Lordship, and for the appellant. Lordship, one of the appellant has died recently, Lordship, we have got the information yesterday only. Lordship, in this time to file the substitution, we have informed the other side. It may be adjourned for today, Lordship.
My lord, I am for the respondents.
Appellant number 1, Lordship. We had no objection, Lordship. We have no- Lordship, that also we don't know. We have just got verbal information yesterday from one of the applicants. So we will have to take necessary information and file the. Obliged, Lordship.
Deeply obliged.
Expert.
For admission, item 1 with 2.
Where, please? In this case, your lordship, there are three items. One has already been decided. And the two is listed here. Yes. In this case, the question is regarding the service of notice. Here, if your lordship come to the page 34, that is the appellate court order, page number 34. So the relevant page is 38. Para 8. I have carefully perused the copies of the summons returned by the servicing officer with report. It appears that the serving officer made 5 attempts on such and such date to serve the summons upon the appellant Sri Tarun Gogoi, but could not succeed, and on 4 occasions he has informed the court that defendant was not found, and the people of the locality has stated that he resides in Kakopothar. And on occasion, he had informed the court that the people of the locality could not identify the defendant. Thereafter, the court was pleased to direct the publication of the summons in a local daily fight order dated 13/8/2007, and which was done on 19/2/2008. And the learned Munsif, accepting the paper publication, had ordered that the suit proceed ex parte against the appellant. Then I have carefully perused the relevant provision of CPC, and Order 9, Rule 13 specifically provide that in case in which the decree is passed ex parte against the defendant, he may apply to the court by which the decree was passed or an order to set it aside. And if this satisfies the court that the summons was not duly served. Now, the next relevant is Para 11 in your lawsuit. 39 page. It appears that the serving officer made 5 attempts for the service of summons upon her, but he could not succeed. But the report of the serving officer do not disclose that he had obtained signature of any witness at the time when he attempted to serve the summons. The serving officer submitted report that the people of the locality stated that the defendant resides at Kakopothar, but
he did not cite the name of any person who had given him in the information. It is true that every court is empowered to order for service of summon in a substitute manner, and in this particular case also, court has ordered the summon same by publication of the summon in the local daily. The Order 5 Rule 21 provides that when the court is satisfied that there is reason to believe that defendant is keeping out of the way for the purpose avoiding service, or that for any other reason the summon cannot be served in the ordinary way, the court shall order summon to be served by fixing a copy thereof in some conspicuous place in the courthouse, and also upon some auspicious part of the house if any defendant is known to have last resided or carried on business or personally work for gain, and in such manner as the court thinks fit. As such, it appears that before resorting to the mode of substitute service as described in Order 5 Rule 20 CPC, the court is to be satisfied that there is reason to believe that the defendant is keeping out of way for the purpose of avoiding service, or for that any other reason the summon cannot be served in the ordinary way. In the case in hand, the learned Munsif had ordered service through substitute manner as defendant could not be traced out. The order of the court below does not reveal that the defendant was keeping out of the way to avoid service of summon. It appears from the record that titles of number 37 2006 that White Order 22-3 2007, the plaintiff was allowed to assist the process server to trace out the defendant for proper service summon, but the report of the service officer do not disclose that he was ever assisted by the plaintiff. In all of the report, the service officer stated that the defendant resides at Kakupathar, but no attempt was made to collect the exact address at the Kakupathar. It cannot be denied that someone can be served in a substitute manner by publishing in a local daily. But reality is that everyone in our country do not go through the newspaper daily. As such, endeavors should have been made for collecting proper address of the defendant and service of the summon upon the defendant personally. And it appears that the White Order dated 22-3-2007, the plaintiff was allowed to assist the process server to trace out the defendant for proper service summon. As in my considered opinion, before the resort to service of process through substitute manner, some more efforts should have been made for service summon personnel by collecting the proper address of the defendant. This is the opinion of appellate group. Though there is a paper publication and it is admitted fact, but it reveals that section Order 5 Rule 17 has not been followed. But whether it is necessary to follow before the publication of newspaper. Yes. And there is an order of the court, trial court, to publish the notice, and accordingly it is published. So service of the summon is served, your lordship. That is completed. I am the plaintiff. Dibrugarh. Yes. Yes. But there isn't publication. And the Rule 20 doesn't say so. Order 5 Rule 17. But this, yes. But that has not been done in this case. That has not been done in this case. No. But only my question is when we have taken the resource of publication as per the order of the court. And the earlier petition was also rejected, but there is a difference. There is a difference that there is no paper publication as per the order of the court. But but this procedure is going on, Your Lordship. And in the High Court, we never follow the other provision. That I have already admitted because that has not been done. The plaintiff has taken the step as per the direction of the court. No, your Lordship, already one has been decided, so your Lordship has decided. Because it is time consuming, Your Lordship.
Six.
Six, six. Six. Not exactly. In case of, there are two uh, respondents, that is one and two. So one, in case of one, it is same. But in case of two, that is the defendant number 8, before publication in the newspaper, the ex parte has been proceeded here. Yes.
There are two.
One, number one, paper publication, and number two is, number two respondent, in case of respondent two, that is refused.
Number 2 and defendant number 8.
8. 2 is for paper publication, 8 for refusal. Yes.
Defendant number 2. And potential defendant number 8. Defendant number 2,
Then paper publication. And in case of 8, refuse to accept. order passed on 13/7/2007. Yes, there is an act. No. Thirteen seven 2007. Yes. They refuse to accept. Therefore, the summons are ready, duly delivered to whom have been served duly. Proceed with expertise. That is in case of event number 8. Joint application. They have filed jointly appeal. to defendant number two. Respondent number one is defendant number two. Two. Junior division. Fifteen six.
Now this, agreed by the impugn order, he wants some amendment under order six, order 6/17, but that was denied by civil judge Dhubri. My lord, here, my lord, petitioners predecessors, the owners of the land, my lord, and with the defendant, respondent, she entered an agreement for development agreement, page 42, annexure A. That is Madhuri Borua, he is the owner of 4 kotha for 13 acres of land, Dhubri town, First Mahal, and the agreement was entered into, and my lord, page 43 is the development agreement. Page 43, my lord, annexure A. Page 43, annexure A, my lord. Playing is 76. Oh, I am sorry, I am saying agreement. Here, the specific performance of that agreement, my lord. So, in that agreement, my lord, owner's allocation was 30% of FAR of constructed plan as per plan, and developers' share was 70%. Here, my lord, when allotment letter is given, the ground floor, that is not mentioned in allotment letter. So against that, he filed representation, but when no response was found,
can read. And my lord, MA petition is page 113. Where is my lord? 113 is the amendment petition. There are 6, page 114. Therefore, it is placed that your honor would be pleased to allow this amendment. Impeach order, my lord, 132, 34, yes, 132. 32 from 34. Relevant is 34. No. 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 No, my lord, that no documents existed like that, my lord. That is their pleadings, but not supported by any documents. He construed one sketch map as the relinquishment or, my lord, relinquishment ground floor, my lord, annexure B, my lord. So this is at the time of agreement, they showed the location where our flats will existed, but page, my lord, annexure B, page 58, 60, not 60, 67. This is the basis of the innovation agreement according to interpretation of learned civil. But this is when agreement was entered into, only show that their location of flats to be constructed will be this. But here ground floor, there is no mention about ground floor because ground floor they have keep it open, not started here. So now they said that since I put signature my predecessor, I am satisfied with this first floor to sixth floor. That is the interpretation. But no such relinquish agreement, novation of agreement, nothing else. Nothing. This is also signed on the same date of agreement, 21/2016. That day only sketch, rough sketch map is shown that your location will be this, first floor to sixth floor. Now about ground floor, no mention about it. 21/2016, same day as the sketch map was also provided. Construction yet to be started, my lord. So relinquishment does not arise. And second point says that where there is no mention that you have already your exhausted, to that effect, nothing agreement. Agreement is 30% of all the floors, including ground floors. And page 69, as per plan, it is written ground floor also they have construct. So we are entitled to ground floor when they have not given with specific performance. We start to file the suit or specific performance. Then we came to know they themselves said that we have already sold. That is why median of necessary parties. Then we filed amendment petition. Now they objected the amendment petition.
For developing their land, the mother was the institution for the
Don't just speaker. Yes.
As per development agreement, the owner, that is the predecessor interest of the petitioner, would be provided lordship 30% of the area lordship of the building lordship. And in that respect, there is a already development agreement. There is a mention lordship that they will prepare a sketch map on this regard, showing the allocation of the owner's allocation lordship. And in pursuance to which lordship that sketch map was prepared diagram, lordship it was accepted by the late Madhuri Burwa lordship. And thereafter lordship, initially it was decided to construct the building up to 5th floor lordship, and on the basis of which this sketch map was prepared. Subsequently, another floor was constructed lordship, in which also the owners was the predecessor, the petitioners were handed over the flats lordship. And in this regard lordship, your lordship kindly come to page 70. That is the letter issued by the lordship respondent number 1 and 2, that is the developer, to the predecessor interest after the date of Madhuri Burwa lordship. And in this letter lordship, they already received the flats which already handed over to them lordship without any objection lordship. And lordship, they filed the suit lordship with the knowledge that the developer, there is a averment that developer is allotting the area which falls under ground floor lordship, and as per according to them, they would also entitle the portion in the ground floor also lordship. Here in this case, they sought the person they sought to be implicated in this case, they are subsequent persons lordship, and they filed a suit lordship for specific performance of contract lordship, and they try to they by filing this amendment petition sought to be implicated the person lordship who they are not remotely connected to the original contract lordship. They purchase land from the developer lordship on different floor lordship. But the petitioner claiming their lordship area on the ground floor itself. But and all the person lordship as mentioned in the lordship in the amendment petition lordship, they purchase on different floor lordship. But their main claim is on lordship ground floor. And they also sought for cancellation of the sale deed lordship of the person who have purchased land on different floor, first floor, second floor, third floor lordship. And they all, by this amendment, they sought for cancellation of their deed also lordship. But their basic claim on the ground floor lordship. If your lordship go through the amendment petition lordship, kindly come to case 113 lordship. They mention and cancellation of sale deed of innocent buyers, those who are not remotely connected to the original contract lordship. The petitioner also sought for lordship amendment to the prayer itself lordship, seeking a prayer for an injunction restraining the lordship, the circle officer and DC, not to mutate the name of the person they sought to be implicated in this case lordship. But they have already mutated their name, lordship, their land before filing this lordship amendment petition lordship. If this amendment is allowed lordship, it will change the nature and character of the original suit lordship. And
My lord, as per, we
We are
have
adjourning the matter.
yes, my lord,
We are adjourning the matter. You are disturbing when he is arguing.
oh my,
No, we'll take it up next week. List after a week, both sides are represented. List after a week as the learned counsel for the petitioner interjects while the respondent side counsel is arguing.
sorry, my lord, that's misinterpret my note, but I think. you have-
Keep on,
Yes,
uh,
I understand.
after 2 weeks. You want to speak anything more? We are making it 3 weeks.
No, I'm sorry, only so sorry.
Take a break and come.
Worship in this matter, respondent number 2, he has expired on 30/12/2025, my lord. And his legal has,
Right, respond number 2.
yes, my lord. And his legal words are required to be substitution, my lord. We have IA file already, so some other defective, my lord.
Okay, died on?
IA for substitution, my lord.
No, but he died on when? Which date? Respondent number 2 died when?
Yes, my lord. Respondent number 2 expired on 30/12/2025.
You filed an IA.
Yes, my lord. There is some defected, my lord. So sometime may be granted, my lord.
Your name?
R.I. Bhuya, on behalf of NH Mother Bhuya.
Mr. R.I. Bhuya, the counsel for the applicant, submits that on death of respondent number 2 on 31/12/2025, and interlocutory application for substitution has been filed. So how, the same is effective and he pays for granted a week's time to cure the defects. Next, Mr. K. Mazumdar, and counsel for the respondent is present.
Obliged.
First after a week.
My lord, kindly date in a week.
You will cure the defect.
Lordship.
Make a mention if it is done in a
Lordship,
week's
yes,
time. Make a.
Actually, unnecessary delaying, it is a survey matter, lordship. It was referred to for survey of the land and demarcation, for which the matter is pending since long, lordship. Right,
2020 appeal.
lordship.
We give a date.
Anyway, subject to convenience, lordship. Please. So, for substitution, if we can be disposed, lordship. Thank you. Oh, March 11th.
Yes, item 5.
May I please, your lordship? Lordship, I'm praying for adjournment of this matter for today. As anyways, council is having some medical issue, so she went to medical for treatment.
It may be in the next 18 to 19 lordship.
Take up next Monday.
Next month, on 18.
As the representative of the prayer made by the applicant, the matter changed to today. Next, Mr. H. Sharma, H.K. Sharma and talks to the respondent is present. This talks 18, 5 and 26.
Right, lordship.
Item 6 for orders.
For the office note dated 8/5, it's, respondent 1 and 9 has expired, my lord. So I may be allowed to take steps upon the legal heirs of respondent 1 and 9. Then the principal respondents are respondent 1 to 12. So from 13 onwards is all pro forma. Parties who have appeared are respondent 2, 3, 4A, 4B, 4C, 5A, 5B, 7, 44, 45, and 46, my lord. I have instructions, my lord, that apart from 44, 45, and 46, from respondent 13 onwards, they may be struck off, my lord, because they are pro forma respondents. 44, 45, and 46 have appeared.
We will now take steps against those.
I'll now, legal heirs above respondent 1 and 9, they have died. Then, my lord, 2, 3, 4A, 4B, 4C, 5A, 5B, they have appeared.
9 has also died. but
1 and 9 has died, so I will take steps legal heirs above legal heirs of 1 and 9.
Not only, there are a lot of people who have died.
So those are pro forma, my lord. From 13 onwards, 13 till 50, they are pro forma.
So you want this 13 onwards to be struck off.
Yes, except 44, 45, and 46, they have appeared.
44,
44, 45, and 46. They have appeared.
let's found letter counsel for the appellants. Has submitted that the respondent numbers 13 to 49 are pro forma respondents. Not contest the good, right?
Yes, my lord. 32, it's still 50, my lord, 50.
50.
50.
50.
And appearing on behalf of respondent number 44, 45,
Just now, we'll take note of that. First, we striking out orders between parties. And as respondent numbers 44, 45, and 46 have appeared, I raise that the name of respondent numbers 13, to 43 and 47 to 50 be struck off. Struck off. That is allowed, and the names of respondent numbers 13 to 43 and 47, 50 are struck off at the risk of the appellants. Let's go.
I'm appearing on behalf of G. Bharadwaj.
For respondent numbers,
2, 3, 4, 1, 4, 2, 4, 6, 5, 1, 5, 2, and 7.
241, 54A.
Cordially repeated for 1. 2, 3, 2, 3, 4,
4A, 4B,
4C, 5A, 5B,
5A, 5B.
and 7.
And
7.
7.
Yes, sir.
Your name?
S. Lipusa.
S.
Lipusa. On behalf of G. Bharadwaj.
Please write the spelling and make a little people. Done const for enters appeals for respondent numbers 2, 3, 4A, 4B, 4C, 5A, 5B, and 7. And Miss,
Lordship, I'm appearing on behalf of respondent number 44, 45. and
your name.
Parveen Parikh.
Enters appeals for respondent numbers 44, 45, and 46. Next paragraph. The learned counsel for the appellant has submitted that he is required to take steps for substitution of respondent numbers
1 and 9.
1 and 9, who have reportedly expired as per the postal remarks. According to magistrates, returned whenever the magistrate issued the liquid as well as the this after
After 4 weeks.
this after 4 weeks.
Much obliged. Obliged.
Just a moment, there's an IA.
I therefore say the records have already been called for. Madam. The records of the appellate court has come. I'll serve them copy also.
In this IA 726, right? But this has come for the applicant, also for the respondent, also. Next one. This court by an order dated 16/3/2026 directed steps to be taken for issuance of within 3 days. This court 16/3/2029 directed steps to be taken within 3 days for service of notice on the respondent. As per the office note dated 8/5/2026, no steps has been received by the section for service of notice on the respondent. Next, by order passed today in connected RSA 24 of 2026. The names of respondent numbers, so 43 and 47 to 50 have been struck off. Consequently, the names of the said respondents in this application have also been struck off. Next. By the said order, the court has also reported that the respondent numbers 1 and 9 have expired. Steps required to be taken for doing the deed. Next, the matter stands adjourned. This after 4 weeks. As in the connectivity business.
Item 7,
May please, Your Lordship. My Lord, office note dated 4/4/26 says service on respondent number 2 is not complete, my lord. However, my lord, perhaps we'll have to give better particulars of the respondent number 2, my lord. So service report otherwise has not come, my lord, but with this address, perhaps it will not be possible. So I may be permitted to give better particulars.
Respondent number two.
2, my lord. It's otherwise a formal.
Tribunal.
It's a tribunal, yeah. It is otherwise perhaps, it's been made a party only as an abundant caution. For the records primarily.
You have the act, copy of act.
Yes. Section 7 is Constitution of Israel.
Get an address because we.
Comes, she's come.
Someone from the medical school. Correspondent number two. Okay.
Service is complete.
Who are you?
I'm the son, my lord, against whom there's an eviction decree at the instance of the farmer.
Appropriate, in fact. As long as that order. You won't maintain your parents and then you stay here if they're, you disturb them. What is the age of your parents now?
My senior citizen, who's a 70,
years probably. 74 years. He's staying out of his house since year and a half. Since year and a half, he's been out of his house for now. Since a year and a half, he's been chased out of the house. He has been residing here in
Parents.
the father. The mother is expired. Only the father. He has approached the tribunal, and then an eviction decree.
Gone out.
Yeah, and then an eviction order was passed rightly.
No, we are more on the procedural part. Of course, allegation wise, there are severe allegations that I harassed and all of that. But we've refuted.
Ultimately, it's your father, he's a
True, my lord. In fact, we proposed mediation also, my lord, but
Which will never happen in case like this. It will never going to happen.
Lord will have it for admission, my lord.
We are having it for admission, don't worry. We're not dealing this matter when the other side is a senior citizen. Mediation will never happen. The reason is very plain and simple. You,
Lord, my stand, of course, has been that he's moved out on his own, my lord. He has of course, those are disputed questions, my lord, which is why we said that
you are challenging it, you see.
we are challenging it mainly on the ground that no inquiry whatsoever was conducted. I was called to file an objection, my lord. I've made a categorical statement. Had they called me for a hearing, I would have done that. But if the AKM here is otherwise appearing, my lord, can I pay for some accommodation on that ground?
No. See, he's out of house. We are not adjourning it. At best, we can adjourn this for 1 or 2 days, nothing more. If he's your father and he's been out of the house.
My lord, I have made categorical statements that I have never driven him out, and still the doors of the house are open. In fact, it's his house, my lord. Though my mother may have contributed, but that's besides the point, my lord. That has been my consistent stand. Now, according to us, my lord, the respondent is adamant. He wants me out, only then he. I mean, the rigor with which it has been fought. Yes. That's right, that's true. Seems, yes, from the record, whatever little I know.
Well, this order was reasoned, and this was heard after hearing both the parties. So before that, mediation was already failed when this order was passed. Well, Lordship can have it tomorrow.
Can your lordship have it on the 15th, 15th, Friday? Thirteenth and 14th, I have a 14th, 13th and 14th are the only dates I have difficulty. Rest any next 2 days only.
Your
19th.
lordship, tomorrow, you're fixing it up?
19.
19?
I'm on board.
Yes, sir. Madam, may I pay it on 21, 19 is Tuesday, Thursday, 21. I think okay, what Tuesday or no? No? It is open local. Your lordship may be able to fix it on 19 minutes. At this, I have a PML matter in the appellate panel that can be adjourned. Well, I'm sorry. Well, 19, I thought that it was a Supreme Court matter, but it's a tribunal matter. It can be always accommodated. Because your lordship said that in. Yeah.
Note one thing, my lord, 8-4, my lord, the records were called for, my lord, for him.
Records are all there, madam, in the.
Well, because that's my only ground. That is,
We have
no
enclosed the.
dates were fixed, my lord. It was passed behind my back. So the records will reveal. That's the only procedural ground that I have. My lord.
Yes, madam.
We were provided with through the order, we've annexed that. Your lordship will find my specific statement at para 9, 10 and 11, 10, 9 and 10. In fact, on merits, we have very little to submit.
And-
my lord. That's
and
the only ground that the inquiry envisaged under 5
These are all summary procedure.
has been, could be summary, my lord, but at least.
But
some
it
minimum-
was hard, record was produced, madam. Your lordship will
That's
say
that's
that,
my
that's
statement.
the
That's
impugn order, your lordship will say.
Para 9 and 10 of course.
No, I got this to be sure. Your lordship may see the page 12 is heard the learned counsel for the applicant senior and the learned counsel appearing on behalf of the respondent peruse the application, written objection, documents and materials on record. The saddest part is, Malak, this senior citizen, who's Malak? No, Malak, their primary ground for coming directly to the High Court was that there is no maintenance to appellate tribunal. I'm told that there is. Deputy Commissioner has been empowered, Malak. Your, so your lordship will fix it on the next week. We'll bring it on, if you can get the copy of the notification, because then alternative efficacious remedy is there. But problem was that the order was passed in February to take them, directing them to take dusty service as well as speed post. They have only taken a normal, and there is no. Huh? I said. No. Senior citizen. If your lordship looks into the Senior Citizen Act, earlier, if your lordship looks into the appeal provision, your lordship will find that it was thought that only this aggrieved senior citizen can come. But later on, the courts had clarified that even the sons and daughters and also can come under the appeal provision. I think it's section 19. Wasn't it? It will be section 16, appeal provisions. Sixteen was the earlier appeal provision. Yes. Yes. Yeah, well, I think the deputy commissioner is because he is the social. So he is the deputy commissioner. DM is the. My lord. Yes. Yes. My lord, here also the High Court, my lord, it was referred to the mediation and all, it failed. Yes, but probably because here the matter, the High Court referred to the mediation failed. That's why the matter was remanded back, my lord. We came. And most saddest part is, my lord, this. Ten, 11. You come over to Nandini Mukherjee. 12 minutes. Your lordship may fix it next week, my lord. I'll be in a better position to assist because today my learned friend said that he will seek time. That's why I've left it, my lord. Yes, sir. Thirteen. But your lordship will at least first see whether there is a maintenance appellate trap. Yeah. But your lordship will look into it next week, my lord. I'll be because today I did not bring the Assam tribunal that effort. Yes, yes. Yes, yes. No, there's nothing. The law is law. I'm only an officer of the court, but I'm only more compassion towards this because I have been because this is the first case in Assam which I moved it, and because of this tribunal was constituted. And but now to teach them the procedure, my lord, it will be a very difficult task for me, my lord. Because then your lordship has seen the first proceeding we started in 2024. Still, yes, ma'am. Yes, ma'am. So your lordship will take it up next week, my lord, on a convenient day to your lordship, my lord. Will be talking. the message. The MLA को बिना करो. Thank you. Thank you. 21st, I'm here, madam. 19, but he said that 19 again, it will be difficult. Wait. Oh, sorry.
Right.
Just day before yesterday also another came on this matter because this is a new law developing where the daughter-in-law's right of under the Domestic Violence Act, Supreme Court said no, the senior citizen's right will prevail. Yes, ma'am. Just, huh? Yes. 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 Because 24, we have been fighting to put this gentleman in his own house. We are unable to do it.
Item 19 for orders.
Lordship, the matter is ready as regards the service and PCR. It can be posted for hearing.
Hearing, my lord. On
A date to be fixed for
date
final
will fix, my lord, in the month of June. In June 9th, it may be fixed for hearing, my lord. Subject to lordship convenience.
And the printed.
And for defendant. So I could let me speak.
Page 31. Super judgment.
Title appeal is in 14 page number. My lord, in the month of we have some problem, my lord, in the month of June, 10th June, my lord. My lord,
20. 19 is okay. Manish. 19.
26 of 20. My lord, can you be on 26, my lord, it's final, my 26. Wisdom. Highly obliged, my lord.
Obliged, Lord.
Item 8, hearing.
Well, short point will evolve here, not. You have also seen the point substance question of government. After one is they learned that first appellate court that it has the penalty was in respect of land, not in respect of house. By disputing the 20 story is justified in holding that the defendant has no right to repair the house in view of the provisions contained in section 5 of the Assam non-fair holding. This is the only. Now, if you also to see that appellate court judgment, madam. Madam, 2. Yes. Madam, that is like a property problem. Madam, is, yes. Wait a minute. Yes. Wait a minute. Yes. Yes, I am. In that, let me know. Page 71. Mike 71. Last part, paragraph 14. In return, the appeal is partly allowed on the contest. No, before that, my lord. Paragraph 37. Page 71. Paragraph 37. I was the same. Paragraph 37, if you also see, my lord, at page 71. The suit house is situated in the jurisdiction of Dumduma Town Committee in view of above. The suit involved in the appeal is governed by Assam Non-Vital Urban Council. And this honorable court earlier allowed us to repair the house, madam. This honorable court earlier allowed us to repair the house. By the, madam? Well, that is the, madam, order, madam, one IA was filed. IA, madam, 669 of 22. It was allowed on 24/6/2022. Repairing was allowed. So the house is constructed by me, madam. So they go far, not governed by rent control act, madam. In fact, the appellate court also allowed the construct, allowed the defendant to repair the house, but in presence of the plaintiff. Only part is in presence of the plaintiff. Without changing the nature, yes, yes. But he is
penalty in respect of land, because rent receipts were proved, my lord, which were yearly rent of 70 rupees per, my lord, year for land. If your lordship will find at 68, page 68 last para, my lord, that your lordship. My lord,
There was no cross case in this, counter claim is not there. But then, please come to page 59, paragraph 22. Case number one failed to come to the doctor to testify himself without reason. That will be matter admission of PW1. That yearly rent was so and so, I have found no reason to disbelieve the contents. What does this mean then? Somebody else came for giving evidence.
so para 28, my lord, ultimately it was 69, so lord, the finding is there, that their case is not. Now they have not challenged this judgment, my lord. The finding of the appellate court becomes final. So far, the tenancy in respect of land is concerned. And then, some non-vehicle urban maintenance.
Only land,
Madam,
only land.
only land, only land. So, madam, there, so ultimately we have to challenge, madam, that the para 40, madam. That is the, there cannot be any such restriction, madam, that they have to repair the house, madam, in presence of the plenty for. They have not filed a suit for eviction of it. That's enough. The construct is a permanent structure, madam, wood and tin, there. Admittedly, we have filed a suit for declaration that the defendant shall not be allowed to repair. Declaration that defendant has no right to make any addition, alteration, or modification or demolition and repairing works in the suite premises. The suite premises is a house. We have claimed that we have constructed the house. And in the written statement, they have claimed that father of the defendant took the land from the father of the plaintiffs, and they have constructed the house. And in respect of that, they have shown some rent receipt. So, in the title suit was allowed in our favor, but in the appellate court, repairing was allowed. Repairing has been allowed, but the only rider is that in presence of the plaintiffs. So since they repair, at that time they had started some repairing, and that has subsequently been allowed by the trial court also and this court also in the year 2022 when they have shown some repairing is necessary. So in my humble submission, there should be no grievance against this judgment. And since there was no counterclaim and they have not claimed ownership over the land also, so they have categorically admitted that land belonged to the plaintiffs. And now, and
Question of section 5.
yes, and one more thing they have admitted, there are two katha of land, and as per schedule of the suit, it is 2,000 square feet. So since the house is on a land over 2,000 square feet, so if they are allowed to change the nature and character of the land, they may construct they may construct on the other area of the land also. So without there being any counterclaim, they have categorically admitted in their cross-examination that house is over 1 katha of land. May I read the cross-examination of the appellant?
The query which we had. For example, in this case, the declaration is only for the purpose that there shall be no construction or demolition or repair or anything that happens. That was declaration. Immediately, by that degree, it means that you're not the owner of the house,
Yes, I'm the owner. I'm the owner of the land.
correct?
Yes.
House, you're not the owner. Can there be a injunction of nature
Lots of
in respect of a property which is not owned by the plaintiff?
Repairing has been already repairing has been allowed and
That creates an obstacle on your part.
lots of.
You see, have you read the buildings, this is an, actually, what you call it? Village land, or now it is a town land.
Town. Therefore, it is under Assam non-agricultural urban agency. So under municipality area.
The municipal area,
Municipal area. Admittedly, it is the land is under
Gauhati.
municipal area.
Gauhati or
Dumduma town, Tinsukia. It is under Dumduma town committee.
what municipal?
Yes. This page 101. Well, section 5 and then 6.
So not this, the municipal, some municipal act.
Assam Municipal Act. Assam Municipal Act, I know. Yeah, perspective after taking permission from the Dumla Municipal Board, and they have allotted holding numbers.
To see volume 16. Can you just? Check to what you say. My limited understanding, if you read section 3, subsection 39,
Section 3, subsection 39.
39, and then 174. Just come closer, Mr. Saiwala, you can.
Section 3, subsection 39.
39.
Redact and expression. Instruction.
174.
174. Order the sanction on.
In the next page, you will find 4 or 5. Re-election. I am interested in that.
4 and 5.
4 or 5, whatever.
Giving permission.
Shall be obligatory for the board to confirm.
No, only these two provision.
It is,
Then,
board permission is always necessary.
no, it's okay. I'll just come to it. You see, under the building bylaws,
Yes.
you see, unlike this Urban Area Rent Control Act, repairs and all, you'll have to go to the court to get it. But under the Municipal Act, you will not find the definition of repairs. At least I don't know about it. You just check it because these things are, I have read, I don't know, about 20 years back. So the repair is not defined. And 174 says the penalties and it says about re-erection. It does not say about repairs and renewals.
Re-erect.
Re-erect. Re-erect would always mean the demolition of a part and re-erection. But repairs as such is not covered. That is my impression of this law. Therefore, if it's a land covered by Non-Agricultural Area Tenancy Act and the premises is situated within the some municipal act areas, if there is no provision for any repair to a house, unless it is re-erection, repairs can be taken out by the by anyone who is in possession of the house without requirement of any permission from the authorities.
Yes.
Correct.
Now there are some building bylaws other than Gauhati also there.
No, that is there, but you see,
The repair has been included in that
the
area.
municipal act is not done away with.
Yes.
Because there are two laws which prevails. That can come through. There's an act called building bylaws. Assam. Other than Gauhati.
Other than, here is, I think,
Other than Gauhati.
other than Guwahati Act will apply.
Building by the GLT propagation.
Now, same will Other than Guwahati, other than Guwahati, can also it has total law.
This is a yellow book, building bylaws.
Oh, hold on. Other than Guwahati, something also they are looking to it. Oh, okay. Now, one uniform bylaw has been, issued, government for all, including Guwahati.
Including Gauhati. This one.
That is prior to that. A new bylaw.
It's a new one.
Malad?
It's a new one.
Oh.
The old act also is this old, even if it's no longer there, but here also you will find.
Earlier Act was 2014 Act. Assam
Okay.
notified urban area other than Guwahati building rules 2014. Now 2022. Nothing.
Assam. Unified building bylaws.
Unified.
Unified building bylaws.
No, here also in the old act, I am not aware of the new one.
Assam Unified Building Bylaws.
It's okay. I will show you this. Here also interpretation clause 57. Re-erect.
Construction.
New act I am not aware.
Time or subsequent further time to be removed or a part of after demolition.
Yes. So that's the reaction. Therefore, you see repairs is not there incidentally.
There's an 58 to make alterations. Means you make any modification in any existing building by way of addition or alteration or any other change in the structure which alters
Which alters. So that means it's a deviation from the design.
specification of the building structure which shall also include.
So that repairs is not there. Repairs would mean coloring, painting, and then if there's a cement or mortar coming out, they will repair it. That's not covered in these acts. So therefore, I can understand the code prohibiting re-erection or alteration. But if it is repair, how the code can interfere when the law does not prohibit? That is the point which I am asking. There must be an act which must be illegal or unauthorized. And if he is not the owner of the land, he is not the owner of the land, he is the owner of the structure. Can he be prohibited from doing that repair?
He has not been prohibited, only in presence of the plaintiff. He has not been. That cannot.
If it doesn't come, he will not be able to correctly do it.
Presence of the plaintiff means doesn't mean he has been prohibited.
No, not that. But please understand the query. If it is repairs and not re-erection or alteration, then why is that presence of the petitioner required? You see, I have this book. This is a property of the court. There's one page which is damaged or torn. I want to put the sellotape. That book.
It doesn't require permission.
It doesn't require a permission.
Yes. That is.
If lordship wants to add a page, it may require.
Then it will be different. Take it up day after tomorrow or Friday. Let it do that. So if you can get any law where even the repairs are prohibited, then you can understand.
Let it be on Friday, my lord.
Hmm?
Let it be on Friday, because Thursday I shall not be there.
Only that one. If you can find out any law which prohibits that, you will find one. But it is an interpretation of the available input law which says repairs and even of erection of a bamboo post would be going to be a reconstruction. So anything which is added, even if in a hut, you change the beam, it amounts to re-erection. That interpretation I am aware of. That even in a thatched house, if a bamboo pillar or post is repaired, that amounts to a re-erection. If it is only repair in a RCC house, then where it is prohibited and which one is prohibited.
It is Assam type house. Wooden tin, Assam. Wooden tin, permanent,
Yes,
is a permanent construction.
that is a permanent construction. But we are on repairs and yes. That's the only point.
Friday motion day, my lord, whether.
We'll try to take care of, that is the only point.
My lord.
It is the balance either in favor of the petitioner or in the favor of respondent. That's the only point. This book.
Holding numbers are allotted to me, my lord, of the construction because of the town committee. And
Holding.
we are paying.
Is there an evidence? If I missed it then.
My lord, yes, they are, my lord, my lord. At page 19, page 68.
It's there. Holding has come into evidence.
Yes. That I have to check it out.
Holding number is in the name of his father.
Yes.
It is, what is it?
It was construction was there in 1950.
Yes, we need to have both sides. This one. Looks 15. Fine.
Right now, must.
Item 9.
Yes.
May I please lord. We were the defendant in the suit, my lord.
Yes.
Now, suit was filed, my lord, for right title, interest and
on the basis of a sale deed and forecast possession. And sale deed, my lord, admittedly it was executed by elder brother, my lord, on behalf of minor brothers.
Yes.
Then my lord took the plea, my lord, that the brother, my lord, cannot sell, my lord, the property on behalf of minors, as my lord brother is not a legal guardian. So the sale deed is void. And the learned trial court, my lord, issues frame, my lord, case 29. my lord.
This sale deed is of which
Is of 1975, my lord.
75, 2913 or 75?
Clause 18 to 75. And disputed land, my lord, was 4 bigha 2 katha 10 lesa.
This sale deed is for how much land? 4 bigha 2 kata 10 lecha.
Lordship.
The name of the vendor is
Nagar Ali.
Nagar Ali, Noor Islam and Noor Muhammad.
Lordship.
Three vendors.
Lordship.
Is it right?
Your 4, my lord.
Nagar, Kolkata, Shomela, Mohammed, Ramela. 1, 2, 3.
Who are the 4 vendors?
5%.
5 persons, my lord.
Okay.
Nagar Ali was not made party in the suit.
Nagar Ali, Kul Khatun,
Noor Muhammad,
Promila Khatun,
Ramela na Samela.
Shomela, Ramela, letters.
Noor Muhammad,
Select ka single name.
and Romila Khatun.
Second number 5.
You are the defendant,
Lordship.
but in your written statement, you have admitted that Nagar Ali, Noor Islam and Noor Muhammad were entitled to 5 bigha 4 kata 70 lecha land. That you have admitted. So if that be so, then if these people, only these 3, leaving aside the Kul Banu and others, if that sale is made, then it will be a case of partition.
No, they are,
But the sale deed cannot be held to be bad.
in the sale deed, my lord, it is not specifically made that.
We
Lordship.
understand, but even for an outsider to have purchased the land belonging to a Mohammedan family, keeping aside the shares which they have, it's a share in present. If there are 10 people will have a share.
Lordship.
If that share is
Within the
culled out, and still the vendors have right over the, that is your admitted, I think admitted case. 5 bigger 4 kata 17 lecha you have acquitted is the share of these three people. Then the sale deed itself would be valid. He has not challenged that. So Sikdar ought to have made a cross objection. He has not done it. The sale deed would have been restored. You see, I am reading from here and there and jumping to a conclusion. I come to page 28. At page 28, second paragraph from the middle, the defendants have pleaded to in details the land possessed by Yad Ali and conveyed by him during his lifetime and state that Nagar Ali, Nur Islam and Nur Muhammad were entitled only to 5 bigger 4 kata 17 lecha.
Here, my lord, yeah, here, my lord, three persons, my lord.
It's okay, 5 are vendors.
Lordship.
But if this, of these vendors, if these three people,
Three
you see
people,
the vendor here is Nagar Ali,
Nur Islam
Nur Muhammad.
and Nur Islam also.
Nur Islam is not the vendor.
Nur Islam.
Nur Islam is not the vendor. Vendor is Nagar Ali, Full Khatun, Shamila Khatun, Nur Muhammad and Romila Khatun.
Romela, two persons. Nagar, Full. Nur.
You see what I'm trying to calculate.
Lordship.
If you come back to page 28,
Three.
5 bigger 4 kata 17 lecha. We make this 6 bigas. 3 lechas we add here, it becomes 6. So share of each person would be 2 bigas.
Two bigas.
If it is 2 bigas and the sale is with
4 biga.
4 biga 2 kata 10 lecha,
Lordship.
then we have a dispute only with regard to 2 kata 13 lechas.
No, even then, my lord, the one Nur, my lord. Nur Muhammad is also my lord.
We understand we leave his share.
Lord.
His share is one, what do you call, his share will be
2 biga.
2 bigas, we leave
Two.
that. So 4 bigas.
Regarding 2 biga, my lord, he can, my lord. Because this is the share of Nagar.
No, we are not doing that.
Lord.
I'm just trying to restrict the examination
Lord.
on this basis.
Lord.
So if it is 5 figure 4 kata 17 lecha, so only 4 bigas are gone. So therefore, the dispute with only regard to 2 kata 13 lechas out of his purchased property. He has purchased 4 biga, 2 kata 10 lecha. Right?
Lord.
3 lechas is here. At page 28, we are adding this three lectures here to make it bigger. Now we add it here. So the dispute is only with regard to 2 kata 13 lectures. And 2 kata 13 lectures will come out of the share of Nagar Ali Phul Khatun, Shomila Khatun, and Romila Khatun. If that is so, then the first appearance order is not interfered with.
Regarding, my lord,
Your substantial question of law is whether, despite the deed being declared
void, man.
void ab initio, whether the plaintiffs have a right title interest over the suit land.
If the sale deed is valid.
No, even
Other-
if it is, you see, it is void ab initio, but he has acquired some rights. The vendors have not come and said that, no, we, what you call those rights, have been waived by us. That's why I said that he did not file a counter to cross case, cross appeal.
Now, this finding is not challenged by him.
That finding is
Lot.
not challenged.
Not.
But, Mr. Siddiqui, you have not filed a cross appeal.
No, but not filing close.
Then you see your right and the interest over the plaintiff complaint is declared in the trial court. You are the plaintiff.
Plenty. So it was defeat, then they have filed,
They file a
Title
appeal, it was
dismissed.
reversed. And in the reversal order,
Page 53 and 58 findings, man.
59, it is dismissed. And from that, the plaintiffs,
Appeal dismissed, my lord.
so you are the defendant. Your appeal is dismissed.
Dismissed. But findings, my lord, page, paragraph 24, page 54 and paragraph, my lord, 27.
Page 54,
Page 54, paragraph 24.
20,
24, my lord, last paragraph.
Dia nine. Akibatnya ini luar biasa. Sebelum itu dia. Amang di bawah
24.
but then this issue and the substantial question of law, that issue will never arise then. Substantial question of law would be defective then. It is, that's not your case, and then you will lose everything then. Substantial question of law is whether the lower appellate court committed grave error in law in holding that the plaintiff has right title and interest over the suit land, though the sale deed number so and so by which purchase is void. Where is the declaration of void?
Paragraph 24, my lord. From the above authority, it can be safely held that any sale the deposed so and so is effective guardian is void, and then my lord, paragraph 27.
No, he is reading only one part of it. However, discussed and discussed and decided earlier, is a case that the plaintiff has succeeded in showing that her contest preserves Switzerland for 30 years. And therefore, the title remains with her. Despite
Despite the declaration that it is void.
void, you see, the declaration of void was never there. You see,
No.
that's an observation.
No.
And when the decree is finally
Paragraph
prepared-
27, my lord.
No, you see, what is the order in the appellate court?
Appellate court also.
Decree.
Yes, my lord, paragraph 27, clause 26. Is 48, 58. Yes, 58, my lord. From the above factual and legal aspect.
Is void, but due to non-raising of the objection
Yes,
of
my lord.
affected parties in limitation, the claim of the suit plan declines to also cancellation of being void and improperly hit by Article 59.
Clause
So that's not there. It's
So-
positive findings for the plaintiff.
So, my lord, it was held void,
No,
but because we did not.
no. It says that though it is void,
Yes, my lord, though it
But-
is void.
but due to non-raising of objection by the defendants or affected parties within the period of limitation, the claim of the suit land or for declaration of the right title and interest and for cancellation of the instruments being void and improperly hit by Article 59. So therefore, that declaration can't be given because of Article 59, which lays the limitation.
Now, my lord, the question, my lord, whether void document is required to be challenged.
No,
So,
that's
on
an
our Supreme
observation.
Court said, my lord, void document is not required, my lord. Once void, my lord, everything is.
No, void, there has to be a decree of being void. A mere observation in a judgment of a trial court or a first appellate court without there being a decree drawn up is just an observation. The declaration was never given. It says that this is void, but it is hit by 59. Once it is hit by 59, it is no longer void. Yes, you see this 59.
No.
Fifty-nine is to cancellation in 3 years. You said that though it is void, but it is hit by so and so. Then that means it is not void. Article 59 is to cancel or set aside an instrument or decree or decision of contract.
Clause 3.
Duration 3 years. We'll have extension of time by showing that at that relevant point of time you were minors. If it is minor, then it has to be specifically pleaded, and the plea of minority will be an exception. That will lead to exclusion of time for being a minor. See, vanity is something which is covered by section 6 of the Limitation Act. It's an exclusion of legal disability. Therefore, you have to show that on that day when you file a suit, the legal disability was there and therefore it is within time. It's not there in your case. And he was the plaintiff, you are not the plaintiff. You're taking a defense. If it is defense, then even section 6 is not applicable for you.
No.
And 3 years to start Article 59, that finding goes against you.
Only written statement, my lord, there is a counterclaim also. And in the same is 14, my lord. That plea was taken, my lord. That land was not sold by this defendant, my lord, and they were not aware of the sale deed. And they came to know about the sale, my lord, only receiving the summons. So it was within the time, my lord.
Tell you what has happened here.
Pause. Paragraph 20, page 21. 21, 22. And here is page 24.
You see, please come to the discussions at page 32 by the trial court. Page 32, the last paragraph, is first point of inquiry is exhibit 1 was validly executed on 18/2/75. Correct?
Hello.
Now we proceed in the last part, last 4 lines.
Hence-
Hence, the only option left to the defendant number 1, 4, 5, and 6 is to repudiate the contract of sale made in exhibit 1 when they attain majority. The defendant have pleaded that they have come to know about the sale deed only on receiving the summons of the suit. Therefore, whether the knowledge of the sale deed in receipt or summons would vitiate is a question. Now you omit those things. PW2 is her son, after one paragraph. No, PW1 is 82 years.
So,
Correct. Then,
two.
no. Here, he says about the ignorance. She deposed that her son would know the facts involved in the suit, so situated the ignorance of PW1 about the material aspects in the suit can be condoned.
Right.
Therefore, your witness was not good, but looking at the age, court
Right.
has condoned that. Now come to PW2, 63 years. In the middle, I have perused the cross-examination of these witnesses, but find that their categorical deposition of these witnesses on the point of cultivation of fruit land. There is no cross-examination which renders the deposition untruthful or unreliable. Correct?
Yes.
Now, next para. Thus, the point of oral evidence, I find that the plaintiff has probabilized her possession of this land. Now, Javamati is not executed, but the defendants have exhibited exhibit K, the Javamati for relevant act. Shows that against schedule number 58, the name of the plaintiff was mutated in the suit Patta land on 8/8/88. So next para, so far the knowledge of the plaintiff is concerned, the defendant.
Mutation was done-
Registered
Hello.
sale deed.
Mediation was done on the basis of sit-and mediation, not on the
Whatever
basis
the,
of, on the basis of not sale.
whatever the.
What?
Please get to read section 5 of the Transfer of Property Act, you would know what
Yes.
I'm trying to say. Notice, you have seen that
Yes.
definition. Have you read the definition of notice?
Knowledge.
No, it's quite encompassing everything. See, first we'll read this and then come back to that provision. We were at page 34. In 34, in that first paragraph, it says,
So for
this mutation assumes importance because field mutation is granted on the basis of actual position of the parties. Therefore, existence of mutation raises rebuttable presumption that it was granted because the plaintiff was found in possession of the suit land. Now, next paragraph. They may deny the defendants may deny the existence of the registered sale deed in favor of the plaintiffs, but the existence of mutation in the same patta amounts to actual notice. Now, this is where this notice comes. Now, look at this notice, section 3, interpretation. Please read that. I have also refreshed my memory. I have not read it for quite a long time.
a person is said to have notice of fact when he actually knows the fact, or when, but
For his willful
or
absence.
willful abstention from an inquiry or search which he ought to have made, or gross negligence, he would have known it.
Yes, this is one. Then when you read the Registration Act, you'll find that the registration itself is a notice to all concerned. Registration of a sale deed constitutes a notice. to all concerned.
No, admittedly, my lord, at the time of execution of sale deed, my lord, they were minor.
You understand?
Gosh.
You see, that is why we are reading this.
Gosh.
88
So-
is the 88 is the date of mutation. And therefore,
So, my lord, the question, my lord, whether brother can sell, my lord,
that's
as per Mohammedan law
will
or.
never come.
Gosh,
because you see,
gosh.
the second paragraph at page 34. The defendants cannot possibly deny the existence of such a mutation and keep this apart. There is no pleading in the written statement regarding the mutation in the name of the plaintiff. Therefore, the counterclaim, so far as the Christian void is concerned, is barred by time. This is the finding. Barred by time. And therefore, issue number 10 is declared negative. Issue number 10 is with regard to that sale deed.
Whether the sale deed is inoperative or.
Inoperative void
Got
and able to cancel. So therefore, this 10 was decidedly negative.
No.
And then the appellate finding. Appellate finding says that it is void, but still because of
non-sale
passage of time. Therefore, 59 attracts and therefore should not fight within 3 years goes. Therefore, this observation that the deed is void is merely an observation, not a decree, not a finding of fact, not a decree. Finding of fact is against you. It's barred by section 59. So the substantial question of law on which this appeal is filed has to be decided against you. The memo of first appeal is not annexed in this memo of appeal.
Memo not annexed, my lord. Only judgment,
No, memo of first appeal is not there.
no.
We will send you this record. Please see this.
Here.
The issue which you are raising Look, perhaps it is not on, not on the ground of current. Vishal, just before you finish reading, just two things. Number one, your argument is based on the fact that you became aware later on, before you filed that suit. Correct? It is the first appellate court said that once there is a mutation in 88, you have not noticed. That is not even a what you call the observation of the trial court with regard to that 8888 is not the ground for setting the appellate order. That's one. Second is that because of this intervening factor of mutation, it is constituted a notice, and therefore it says that the counterclaim is barred by time. Now, minority is not taken as a ground, if I remember it correctly, but I loosely read it, I don't remember. Each and every word I will not remember, but loosely reading that ground of minority is not a ground raised for the plaintiffs. And therefore, 1888, that also not being a ground. In fact, in first appellate order, on which you are challenging, is not even a ground raised there. That's what I am trying to say. The premises on which you are arguing, that is not the foundational facts. That's why I'm asking to read that.
Their plea that they came to know only after receiving the notice of this, that is also false, my lord. The evidence.
Also not, I am not on that. We are trying to see if there is a ground. If there is a ground, then we'll hear it.
Right.
2008, I forgot the date, because notice received in 2008. I came to know about this. Actually, in the year 2008, there's a date given somewhere in your ground.
Yes.
One year.
I won't even, because I usually read it. I don't read word by word.
Fifteen to, what semester? Yes. Hello? He was there, my lord, in fact, ground number 6, my lord.
What does it say?
Regarding, my lord, regarding their minority and sold it by brother. In ground number 6, madam.
No, but we showed you this, the grounds which are coming.
Hello.
If one brother is 82 years, it's very difficult to accept that the younger brother would be less than, would be a minor.
Lord, they had, my lord, two mothers, my lord.
So that's okay.
So,
But I'm just assuming, you see, I told you, I don't read it
Lost.
thoroughly. I just read here and there and then jump into conclusion. If one brother is 82 years, even if there are two mothers, the second mother would not have given birth to a child who is minor.
82, my lord.
PW1 is 82.
PW, DW,
PW1
PW1.
is 82.
PW1 is the plaintiff, my lord.
Oh, is the plaintiff.
Lost, plaintiff, my lord. He's the mother of the PW2.
Of the movie.
Lost.
Okay.
Lost in ground number 6, my lord. And in the sale deed itself, my lord, it was mentioned that others are minor. Except one, my lord.
send you this record. Here you have, which grounds you have said? Here,
Paragraph, ground number 6, my
6.
lordship, regarding, my lord,
Yes,
brother's power to sell the deal.
yes. There's the written statement I have sent you. Send you the written statement. This is the written statement. The relevant part is there. Correct.
Lordship.
Same statement is given here. But incidentally, the date on which you attend minority and the date on which you came to know again, that when you attend majority is not needed.
No.
But you say that you get the knowledge from that 2008. Mutation is not there, even there or in the appeal. You see the disability under section 6 of the Limitation Act will be till when? Till the attend majority. Then again the mandate of Article 59 will start. The disability will be till your minority. On the day you became major, then 59 starts running against you
From the majority.
from the majority.
No.
So that is also not the treated case, nor you have introduced your majority. And therefore, anyhow, it is otherwise bad. The ground which you have taken here is only with regard to that minority, but when you attain majority, 59 article one starts, it's not with a ground thing.
Now, my lord, when the, my lord, sale deed is void, my lord.
It's not void, that's what we are telling you.
Because as per Muslim law, my lord, brother is not a guardian.
May not be.
And our Supreme Court also held, my lord, that sale by brother or mother, my lord, is void.
But to what extent? To the extent of others, the claim of others becomes time barred with the with that 1888. Because you see, Mr.
Lord,
Adi,
Lord.
the court is not saying that the right arises out of the sale deed. It says your right extinguishes
Because of non-salience.
because the position is shown. And field the court says that because of the field mutation, the position is presumed.
Presumed, Lord.
And from that presumption, the could become barred by law. That is the case.
Lord.
Effectively, there is no challenge to that finding.
But in our written statement, my lord, that land is within our possession.
So it's
Lord.
in your position. But
Lord.
the court comes to a finding that position is there because it's a field mutation.
By applying the
That finding is
presumption.
not a ground here.
Prohibitions case मैंने तो की थी।
You see, Mr. Ali,
Lordship.
what we find is that there's only one very strong point in your favor, but that's not pleaded case, that's not the case in your first appeal, that's not, neither is the case in your second appeal. The only good point you have in the case is that the trial court gave a finding that you are in possession of the suit land. Once you are in possession of the suit land and it's not been shown that you have been dispossessed, the decree for claiming possession was not sustainable. It can't happen. You have possession and then you recover possession. The two things can't happen together. That's neither the case in your first appeal, nor that is the case in your second appeal. The decree for possession could have been bad, but there's neither the substantial question of law frail, nor that is the presentation in either both the court.
Now, my lord, your lordship can, my lord, have you,
Second appeal you can't.
lordship, any other substantial question of law that is, my lord,
Second appeal will not, because the
your court has power, my lord, to frame, my lord.
in your first appeal, that is not the foundational fact. That the grounds of grounds is not there. You see, when it is based on a presumption of the invitation, that and is declared to be in possession, the contradictory decree.
On the basis of
contradictory.
sit mutation.
That's not even pleaded case. You are waiting for that so much of time to argue that you did not. So you are now saying. Not that case. You would have caused dent in the defense of Mr. Sikdar. But that is incidentally not there in the first appellate court. And the substantial question of law is based on the fact that the deed is void, which is not. Because if the case is admitted on the substantial question of law, hardly have any option to undo that.
No, at the time of hearing, my lord, if your lordship feel, my lord, that further substantial question of law is arise. In your lordship, and frame, my lord.
But you have to demonstrate that it was taken in the as a ground of appeal in the first, if it is waived there, it can't be a substantial question from now. Just check your record. First appeal, it's a ground.
Regarding position.
Regarding position on the ground that once you have been declared to be in possession, you can't have a recovery of position. And recovery is also not stated how much land to be recovered. The decree is itself non-executable. You have grounds there.
My lordship, in ground number 13, that plea was taken, ground was taken
What is that?
regarding possession.
Read that.
For that, while the respondent plaintiff did not establish with cogent evidence that respondent plaintiff peacefully enjoyed the suit land from 1975, and the defendant's appellant illegally dispossessed her from the suit land on 15/2/2008. On the other hand, the defendant's appellant established their counterclaim with cogent evidence that the defendant's appellants possessed the suit land from their father till today. In the said circumstances, the learned trial court ought to have decided that the respondent plaintiff did not able to prove her position since 75 over the suit land, and disposition by the defendant appellants on 15/2/2008, and therefore the learned trial court ought to have dismissed the plaintiff's plaint and decreed the counterclaim of the
2008.
appellant defendant.
Disposition in year 2008.
Loss. Suit was filed in 2008, my lord.
So you're claiming disposition then.
Loss.
That is why it is degree for possession.
That's why they are claiming for khas possession.
Which was never your case. It was never your case. Your case is that you took possession from your, inherited the land and took, you are in possession of the land.
Is the
Never
case of the
admitted-
plaintiff?
You never admitted,
No,
you never admitted their possession over the land.
no.
Then how do you sustain this?
So, my lord, the position by presumption, you lordship indicated, my lord.
Possession is post filing of the suit.
And disposition,
Disposition of the plaintiff is post suit. And therefore you, there is a degree for possession when they did not even ask for that. You sent back the, transport record.
Their evidence itself, my lord, says that the land was in my possession and I was cultivating land through others. And they have disposed in the year 2008, my lord. Their evidence, my evidence and their evidence also supported the claim. That the plea of their possession since 1975 is totally false. That goes to show, my lord, by the evidence of DW 3, DW5 and PW3, PW5. And therefore, the learned trial court has observed that land was in our possession. Till disposed by the defendant.
discuss करते हैं DW. DW को discuss करना है. DW को discuss करना है क्या ना? ये DW discuss करना है.
Which ground you are referring to? 13.
13, my lord. DW discuss करना है DW से.
Legal discuss ना बोलना हमारे तो होता है. Letters pass हो जाते हैं.
DW को allows. Trial court did not discuss the evidence of DW's matter. Only PW1 and 2 has been discussed.
PW2, PW3, PW5 discussed. But trial court held that land was in our possession. We have not challenged in the past appeal about this observation, against this observation of the trial court.
which, which DW says that
My lord, for that, my lord, PW2 is to be read fast, my lord. PW2, PW3 and 5 says that we are cultivating the land as an adhyar of the plaintiff, and that was supported by the DW3, my lord. Lordship may kindly have a look at, my lord, the DW, PW, PW3. My lord, last page of the PW3. Last page, my lord, in the bottom. মই বিবাদীয় মাটিত বাদীৰ তলত আদিয়াৰ হিতিকা হিচাপে খেতি কৰি আছিলো।
PW3.
PW3, my lord. PW3, last part. মই বিবাদীয় মাটিত বাদীৰ তলত আদিয়াৰ হিতিকা হিচাপে খেতি কৰি আছিলো বহু বছৰ ধৰি। মোৰ লগত মোৰ খুৰা কুৰবান আলীও খেতি কৰিছিল। আমি 1975 চনৰ পৰা খেতি কৰি আছিলো। That means they are cultivating the land as an adhyar of the plaintiff since 1977, after purchase. Then, my lord, PW5 also. The short deposition. Last part. 377 নম্বর দাগর 4.5 বিঘা মাটি আছে তার সৰুবেলায় খৰিদ কৰা মাটিৰ দলিলৰ আকিয়া নাছিলো কিন্তু মই তেওঁৰ সেই মাটি আদি খাই আছিলো। Then my lord, DW3 says that yes, Nurul Islam and Qurban, they were cultivating the land. DW3 and DW3, my lord. DW4.
Let's go on DW3 first.
Yes, my lord. DW3, ইয়াদ আলী দেওয়ানক মই চিনি পাওঁ, নাগৰ আলীৰ অংশ মাটি বিক্ৰী কৰিছে কিন্তু বাকী নুৰ ইছলাম সোহৰাৱাৰ্ডীৰ অংশ মাটি বিক্ৰী কৰা নাই। ৰাবিয়াৰ মানে DW3,
yes.
ৰাবিয়াৰ তেওঁৰ প্ৰথম স্বামীৰ মৃত্যুৰ পিছত ইউনুছ আলীৰ লগত বিয়া হয়। ৰাবিয়াৰ ল'ৰা ছোৱালী বিলাক হাতীজানা গাঁৱত থাকে আৰু নিজে পোহপাল লৈ বসবাস কৰিছিল। হাতীজানা গাঁৱত ৰাবিয়াৰ দ্বিতীয় বিবাহৰ পিছত হাতীজানাতে আছিল। কাৰ মাটি কোনে বিক্ৰী কৰিছে মই নাজানো। নুৰ ইছলাম আৰু কুৰবান আলীয়ে ইয়াত আলী দেৱানী দিনৰ পৰা আদি খাই আছিল। আজিৰ পৰা 7-9 বছৰ আগত নুৰ ইছলাম আৰু কুৰবানে আদি খাই আছে আৰু আছিল। নুৰ মোহাম্মদ বিবাদীয়া মাটিত 6-7 বছৰ আগতে ঘৰ বান্ধিছে। এইটো সত্য নহয় যে নুৰ মোহাম্মদ হতে বলপূৰ্বক, there are differences, the other contention are against us, but Nur Islam and Qurban was cultivating, that has been admitted by DW3. Same version, my lord, almost similar version regarding the cultivation of Nur Islam and Qurban. DW4.
Ibrahim Ali.
DW to Ibrahim Ali.
What does it say?
My lord,
No.
I am reading, my lord, last part. Nur Muhammad হতে হাতীজানা স্কুলৰ পিছৰ পিনে বহু বছৰ আগতে ঘৰ বস্তি কৰি আছে। বিবাদীয় মাটি নুৰ মহম্মদ থতৰ জালাল মণ্ডলে গোচৰ কৰিবলৈ নুৰ মহম্মদ থতৰ ওপৰত। বিবাদীয় মাটি আগতে খেতিৰ মাটি আছিল আৰু আগতে কুৰবান আদি হিচাপে হাল মাৰিছিল। জোচিহাটৰ নুৰ ইছলাম চিনি পাওঁ আৰু তেওঁ আদি খাইছিল বিবাদীয় মাটি। বিবাদীয়গণে বৰ্তমান বিবাদীয় মাটিত ঘৰ বান্ধিছে। That means Nur Islam and Qurban was cultivating the land. And that was my claim that here Adiyar cultivating the land on behalf of the plaintiff. Same, my lord, the DW5 last 3-4 lines. বিবাদীয় মাটিত বিবাদীগণে ঘৰবন্দী আছে কিন্তু কাগজ পাতি কাৰ নামত আছে নাজানো। নুৰ ইছলামক মই বিবাদীৰ মাটিত হাল মৰা দেখিছো, কুৰবান আলীয়ে হাল মৰা দেখিছো।
Vivadi is he.
Well, DW, this is DW5.
So he's in position as per DW.
My lord.
As per DW5.
DW, yes, my lord. DW5 and DW34, they are saying that the Nur Islam and Qurban Ali was cultivating the land. And my claim is that they were cultivating the land as an adiyar of the plaintiff. And that has been, my lord, they have admitted. The both the Qurban Ali and Qurban Ali, Nur Islam was examined as DPW3. He admitted that he was cultivating on as an adiyar of plaintiff. The PW5, he is also admitting that he was cultivating the land on behalf of the plaintiff. So their plea that land was their position is absolutely false. My lord, I want to relate to judgment, my lord. But even if, my lord, till it was void, there shall be a decree. There shall be a decree of declaring that this deed was void. State of Kerala versus MK Punya Kanan, number paragraph 7 and 8.
Are they in rebuttal or anything?
My lord, paragraph 7, my lord. It is not necessary for us to go into the merits of the case. We are of the view that the order passed inter partes in CRP dated construct has been final and it concludes the matter. The observation made in the proceeding as at the instance of the first respondent regarding the validity of the order of the board in CRP number so will not in any way affect the legality and validity of the proceeding, declining to impede the respondent number 3 and 4 or the order passed in the revision petition. Therefore, CRP number so it is true that the proceeding dated so were observed to be void in law, CRP number so filed by the first respondent. In our opinion, even a void order or a decision rendered between the parties cannot be said to be non-existent in all cases and in all situations. Ordinarily, such order will in fact be effective inter partes until it is successfully avoided or challenged in a higher forum. Mere use of the word void is not determinative of its legal impact. The word void has a relative rather than an absolute meaning. It only conveys the idea that order is invalid or illegal. It cannot be avoided. There are degrees of invalidity depending upon the gravity of the infirmity as to whether it is fundamental or otherwise. And in this case, the only complaint about the initiation of the suo motu proceeding by the board was that it was not initiated or intimated by the state land board about the non-filing of the statement as required by section so and so. In our opinion, this is not a case where the infirmity is fundamental. Then paragraph 8, referring the Halsbury laws, England, para 26 has been quoted. If an act or decision or an order or other instrument is invalid, it should, in principle, be null and void for all the purposes. And it has been said that there are no degree of nullity. Even though such an act is wrong and lacking in jurisdiction, however, it subsists and remains fully effective unless and until it is set aside by a court of competent jurisdiction. Until its validity is challenged, its legality is preserved. So, my lord, they have, my lord, elder brothers sold the land, but it is also admitted fact that the elder brother has own share. So enters deed cannot be said as an void or illegal. But they have not, they were not in possession as they plead in the WS. It is proved that the plaintiff was in possession of the land till 2028 when he was dispossessed by the defendants. So that fact has been established by the evidence. So their plea is also false. They have not challenged in the appeal about the observation of the trial court. So it's a fit case, my lord, to be dismissed. Anything, right? My lord.
My lord, here, my lord, the lordship will consider, my lord, section 359 of Mobile law, my lord.
359.
Lordship.
Guardian.
Lordship. Guardian of the property of minor.
Yes. 6:20. 25, 25, equal to version.
What's the DW4 is Ibrahim Ali.
DW4
Ibrahim Ali.
my lord. Ibrahim Ali. What is it? DW4 is Ibrahim Ali.
Yes. Yes. 352.
Lordship.
350.
359. Regarding guardian of property of minor. On this point, my lord, I have cited one judgment I have given, my lord. 2009, 1996, 7 SCC. Nineteen 7 SCC. 1996, 7 SCC, 436. Paragraph, my lord, 10 and 10, 11, my lord. Small judgment, my lord. Issue was in paragraph 3. And also, my lord, in another case, my lord, 2003, I'm giving. 2003. In this case, my lord, without partition, my lord, entire cell was, entire plot was set on behalf of minor also. Paragraph 7, my lord. 7, my lord. Disposal for basket.
Mr. Sudhir, which case did you give?
My lord, I'm relying on the
State of Kerala.
State of Kerala. My lord, on this similar point, my lord, there is another case. Gurudhan Prasad Singh versus Joy Prakash University and others. My lord, here, paragraph.
Darshan Singh.
My lord, Durandar Prasad, yes, my lord.
Another Prasad.
Durandar Prasad Singh versus Joy Prakash and Joy Prakash University and others. I'm giving my lord. Paragraph. 22. Correct. My lord. This is, my lord, relevant regarding the, my lord, void and voidable differentiation and applicability of the void and voidable. Darshan.
22.
My lord, paragraph 22.
But Mr. R. Ali Leonard, counsel for the appellant, also have Mr. A.R. Siddhar Leonard. You are appealing for all, Mr. Siddhar?
My lord,
You are appealing for all?
I am for all. All, one more, my union picture.
Appealing for all the respondents. For the respondent, 1 and 2 only. Respondent is 1 and 2. We mentioned that the name of respondent number 32. 12 been struck off. Right, order dated 29/5/2015, asked in MC number 467 of the 2013. Next. This article is section 100 CPC. It's been admitted for hearing. So for the 10/2/2012 on the following substantial question of law. Sir, whether the lower appellate court committed grave error of law in holding that the plaintiff has a right, title, and interest over the suit land, although the said sale deed number 2913 of the 75 dated 18/2/75, by which the plaintiff purchases suit, the suit land is void. Next. In brief, the case, the appellants herein are the defendants in the suit. In brief, the case of the respondent numbers 1 and 2 plaintiff is that if they had purchased Gauhati 10 acres land from Nagar Ali, Full Khatun FUL, Khatun PHQL, Shomita Khatun SHO, MELA, Khatun HQL, Noor Mohammed MOHAMMAD, and PROCEED, Nomera NOMELA, Nomera Khatun, by registered sale deed number 2912/75, dated 18/2/1975. Cell lead number, provide cell lead number 2912 of the 75 January 18 to 1975. And since then, they were possessing this woodland peacefully from the date of purchase and paying land revenue regularly. First of all, the land which is described in Schedule A is the set plot of land measuring 4 bigha 2 kata 10 acres. Which originally belonged to one yet YED, yet Ali, who died many years ago. And after his death, the yet Ali, no, sorry. After the death of Yet Ali, his legal heirs acquired the A schedule land. And the other legal heirs of late Yet Ali and also acquired land as legal heirs. He said, it is projected that he said Mohammed Yet Ali sold this land to the this one, under the guardianship of their elder brother Nagar Ali, Nagar Ali, who had sold his share, and the sold his shares is that all the names of the legal and here's the date of sale of the Schedule A land among the tenants in position of the said land to the organized surface. Projected after the sale. The plaintiffs were in possession of this land and they were cultivating the same to adhere level, PDHI, KR, level. With regard to the plaintiffs. And the name was also mutated in the suit plan. And the name of the plaintiffs was mutated in DAG number 344 under periodic pata number 27 at village Artisana HAPIZANA Moza Jhajmai GHILA ZARI Hilazari. On 15 to 2009, the respondents plaintiffs claim to have been dispossessed by the defendants who had contracted a CI sheet roof house with one asbestos chali CHALI and one bamboo plastic chali house over the foot line. That is, the land contains various darks. And the plaintiffs had right early interest and position over this land. It had become necessary to evict the apparents that depended on this land and for creating a new pata and new dagamba. Most of the plaintiffs that made the following prayers in the state. Page 11, A to E, A to F. The land displayed. The purchase value is described in Schedule A of the the total like it is described in Schedule A and the land. Meaning focus had to figure out the described in Schedule B of the thing. Next paragraph. The let's just finish. Find out the statement from company. Among others, claiming that the registered sale deed number 2913 of 75 with 18 to 1975 is illegal, fraudulent, and void ab initio, and not binding on the main defendants. Case for the defendants for plaintiff is that Yad Ali was the original patata of this land who died leaving behind 14 legal representatives. Claims are disclosed in paragraph 3 of the statement. And according to PO, non-general necessary parties must be kept. It's projected that when Yad Ali died, except for Nagar Ali, all his sons and daughters were minor. Which is the the Patakar of this land died leaving behind 14 legal heads and representatives, but out of them only Halimun Nessa, Surat Jan, Suratjan, Nabiran Nessa, Nadiran, Nessa, Sajidan, Sajiran, Nessa, Hamida Khatun, Karimon, Karimon, Karimon Nessa, Samila Khatun, Samel, Samila Khatun, were implicated in the suit and therefore the suit was back for non-general necessary parties. It projected that the plaintiff purchased the supplant from the defendants under the guardianship of Nagar Ali. But Nagar Ali was not the guardian of the defendant, and no guardianship certificate was obtained, and therefore plaintiffs cannot claim title over this supplant. Therefore, this was not plaintiff. The main defendants claim to be occupying the supplant. Accordingly, it was stated that the case of the plaintiff was part by limitation. Claiming that the case of the petition was plaintiff was all fabricated and confirmed with stating that the entire 70 acre land covered by various dark suspension therein, which stood on the name of Yad Ali. Were two wives, and Yad Ali registration. 5 daughters from one wife and 3 sons and daughters from the other wife. And also adopted one child. So it is that during his lifetime, Yad Ali had adopted had gifted 6 biga out of the scheduled land described in schedule X land described in the written statement to Kitab Ali, the adopted son, who accepted 6 biga of land. Of in the lifetime, Yad Ali had donated 1 biga land to Janada, JNANADA High School, 2 kata 10 acre land in favor of Hatizana, HTIZANA Masjid. 2 biga 2 kata 10 acre land was originally gifted to his sister Sokina, SOKIN, Sokina Khatun. And they had all taken possession of the gifted or zoned land. So, and after the balance land, 5 biga land was taken in construction of PWD road. And according to this particular, Yad Ali was possessing 58 biga of land out of total land described in Chapter X. And after his death, he just 58 biga land were inherited by 2 wives and 3 sons and 11 daughters. Probably say that Rabina Khatun and Haliman Nasa, HALIMN Nasa, and was entitled to 7 biga, 1 kata 5 lecha of land out of ex-scheduled land. And his 3 sons, Nagar Ali, Noor Islam, and Noor Muhammad, were entitled to get 5 biga, 4 kata 17 lechas of land. And his daughters were entitled to get 2 biga, 4 kata 18.5 lecha land by way of inheritance. So the main dependents were managed when their father Yad Ali had died. And the main dependents were never sold the land to the plaintiff. It was further stated that on receipt of notice. No. It was further stated that on receipt of notice of the summons of the court case, the defendants came to know that the land was purchased by the plaintiff through a registered sale deed dated 18 to 1975 from Nagar Ali and other defendants. Accordingly, is stated that the defendants had never sold any land to the plaintiffs and they had no knowledge about the registered sale deed by their deceased brother Nagar Ali. And also claimed that the plaintiff had never possessed this land And the defendants were in possession of the suit land since the death of their father. So as the sale, it was stated that as the sale is disclosed, that the Ul Khatun, Momela Khatun, Noor Muhammad, and Romela Khatun were minors, comma, and the land was sold under the guardianship of their elder brother Nagar Ali, comma. It was stated that Nagar Ali had no right. No, without that, Nagar Ali having not obtained guardianship certificate, had no right to sell the land in favor of the plaintiff. And accordingly, it was claimed that the defendants have the right title, interest, and possession of the district land, and therefore the suit is liable to be dismissed. And accordingly, by filing a counterclaim, comma, while paying for dismissal of the suit, comma, defendants sought for a decree for confirmation of possession of both the suit land and that the sale deed number 2913 of the 75 was illegal, inoperative, and liable to cancel it. Along with other regrets. So I'll have to rise. There's a meeting right now. But the order being this. But Mr. Ali, when it comes to the appellate and Mr. Ali is we got to the appellate. The order being already dictated, which could not be completed due to paucity of time. The further dictation shall continue on. Make it tomorrow. The 13/5/2026. We continue with the oral dictation. Be listed tomorrow again. But can I continue with the dictation in the later part of the day?